fortunate. We're very pleased to have them with us today. We have Nikisha Vaughn from the Caputo and Mariotti Law Offices in, how is that pronounced? Is that Moosic, Pennsylvania? You're muted there. Yeah.
Moosic, Pennsylvania.
Moosic. I forgot to ask you that yesterday. And help us. Where is that in the Keystone State, geographically?
It is in the northeastern part of Pennsylvania. We are located next door to the big city of Scranton.
All right. Now, I think Scranton was made famous by the TV show The Office, right?
That's right.
Yeah, well, it was a lot of fun. Well, you are so talented. You manage your firm's personal injury files from intake to conclusion. We call that soup to nuts here in Florida. So you do it all. You know how to get that client signed and get that positive resolution for the client. Am I correct about that?
Yes, you are.
And you're a paralegal member of the Pennsylvania Association for Justice. And we here at our law firm, our paralegals and legal assistants are members of the Florida Justice Association, which is the counterpart to yours in Florida. And you've been featured in the National Association for Legal Assistants, NALA, award-winning Fact and Findings magazine. So you're been featured there, and you received your degree in paralegal studies from Stenotype Academy in New York City. How long have you been in the business?
I have been a paralegal since 1995.
Okay, so as you can see by both of our paralegals today who are leading us, they appear to be of tender years, but they're actually grizzled veterans. Let's go over to Betsy. Betsy, you're off mute. O'Donnell Law Offices in Kingston, Pennsylvania. How far are you two apart geographically?
About 15 miles.
Okay. All right. What's the weather like in the Scranton area today?
It is the absolute perfect day. 73, very low humidity and bright sunshine.
Well, everybody's going to move from Florida to Scranton now. Well, you have been, Betsy, you've been a paralegal at Nationwide Insurance Company for 14 years. We call that the dark side here at our office.
Yep.
You see the light and come over, and you were able to learn the inner workings of the insurance world. I bet you're going to tell us a little bit about that today, about how insurance companies think, claims adjusting. You would manage those defense cases, and you also work there with Neil O'Donnell and his people in Kingston, Pennsylvania. I also think it's interesting. You have a couple not-for-profits that you seem to have a special interest in. One's the Keystone Mission, which assists grandparents who are raising their grandchildren in northeastern Pennsylvania. And I think this is very important. I didn't know about this. We're going to look at this here in our neck of the woods now. The program purchased a mobile trailer that delivers clothing, shoes, and other hygiene products to grandparents that cannot make it to the mission. And you also sponsor or a support of the Ukulele Kids Club project that provides music therapy to children in hospitals throughout the United States. And you're currently the vice chairperson of the Pennsylvania Association of Justice Paralegal Committee. And in your spare time, and we know paralegals have a lot of spare time because the lawyers, you know, we're doing the heavy lifting, but you're a cake decorator, an avid walker, and a super fan of the Gin Blossoms. I don't know what that is. Maybe you can tell us. What is a Gin Blossom, Betsy?
The Gin Blossoms are a rock band from the 1990s who are still making music. I have been to 57 of their concerts so far, with number 58 and 59 coming up this year.
Well, do tell. Okay. So I think we're going to kick it off with Nikisha today. Why don't you get us rolling and let's see what we do. I'm going to check the chat. We have 42 people on the chat room. We have, this is great. So, all right, let's roll.
So good afternoon, everyone. And I'd like to give a special thank you to Ginger for extending the opportunity to have this conversation with my paralegal colleagues across the nation. And a special thank you to Doug for moderating it. So we're going to get started. Today, we're going to talk about the paralegal's role in preparing the attorney for deposition, mediation, arbitration, and trial. And as you can see from this illustration, the paralegal's role in the operation of a law firm is very important. So, as we all know as paralegals, organization is key. It is an important component of our job. Without file organization, we can easily find ourselves quickly overwhelmed and not in control of the file or the documents that are needed in the file. So what you see on the screen in front of you is a sample of how I organize my files for Caputo and Mariotti. What you see are parent folders, just a few of the parent folders that we use. So for example, the client packet folder would contain the signed retainer agreement. It would contain the attorney and or paralegal notes, as well as any documents that we obtained from the client during the initial intake. The parent folder for the correspondence section would include various subfolders, which would include letters that are sent to the client, letters that are sent and received from opposing counsel, letters sent and received from the lien holder, be it Medicare or another third-party organization seeking to recover proceeds that were used to pay for the client's medical expenses, particularly with the personal injury files. The discovery parent folder would include subfolders for written discovery to the opposing party, as well as written discovery to the client. It would also have a folder for the documents that were received. And in that folder, we would date stamp the documents that were received for easy reference by myself and the attorneys. The pleadings folder, again, would have a few subfolders in there. We would initially have the initial document that was filed, the answer, any other miscellaneous pleadings, entry of appearance, things along those lines. The investigation folder is pretty much self-explanatory. We would contain all of our investigative documents and other files pertaining to the case. We have the records folder, which is also self-explanatory. You'd have your medical bills, your medical records, school records, employment records, any records that would be helpful for the case. And then, of course, the photographs, which would contain photographs of the property damage, the client's injuries, photographs of the accident scene, any visual tool that can be used to help pinpoint the injuries and where the accident took place and the property damage, if any, that would be associated with the file. So here is another illustration as to what could potentially happen or how we would feel if we did not organize our files. So again, just keeping the files organized will help to prevent us from feeling like we are overwhelmed and sinking underneath all the paperwork that is accompanied with our folders. So some of us work in paperless offices, and those of us who work in paperless offices should organize their files as well. Good practice dictates that electronic files should be organized similarly those to paper files. Organizing the files will help the paralegal to reduce project delays, help the paralegal as well as the attorney to keep essential documents in one place. And it can also help the paralegal and or attorney find documents that are needed on demand, or just something that has to be pulled so that it can be reviewed easily without having to spend so much time to locate the particular document or file that is needed. So here we come to the point where we want to talk about summarizing medical records and discovery answers. I've learned that medical summaries are extremely necessary. The summarizing of medical records can give the attorney and the paralegal a very good insight into the client's injuries. It can help to document the client's medical treatment, find gaps in medical treatment if there are any, and can also identify any pre-existing conditions that the client may have not disclosed to us or may have forgotten about. Sometimes clients sustain injuries many years before an accident occurs, and for some reason they have forgotten about it. Medical summaries should be done as soon as feasibly possible. I try to begin my medical summary upon receipt of the medical record. Some clients, they receive extensive medical treatment from multiple providers, and oftentimes the records are voluminous. So if one waits that's before a deposition is coming up, or if one waits until they receive all the medical records, we can easily find ourselves pretty overwhelmed digging through the records and spending so much time just working on the medical summary and neglecting other aspects, important aspects that are needed in order to prepare the case and the attorney for their deposition, mediation, arbitration, or trial. Medical summaries can be done in various formats. It can be done via provider, chronologically speaking, or even in a story form. And the medical summary should always include the SOAP notes, which would be the subjective complaints of the client, the objective findings of the physician, the physician's assessment, as well as the physician's care plan. Summarizing discovery. That is another major tool that the paralegal uses in the law firm. Summarizing discovery is an in-depth review of the opposing party's answers. It can help to familiarize the paralegal and the attorney with the party's assets, liabilities, claims, and positions that are being made by the opposing party. It can also position the paralegal to give the attorney input as to whether and to what extent a deposition of the opposing party or non-parties are necessary in order to gain additional information about the issues in the litigation. Summarizing discovery, again, should be done as soon as feasibly possible upon receiving information from the other parties. Once it is received, you would bait stamp the documents and also begin looking at what the attorney may want to use as an exhibit for their deposition, mediation, arbitration, or trial. It can provide a quick reference to the attorney for objections. It can also open the window to the necessity to require, obtain additional medical records and identify what supplementary discovery is needed. It's also an excellent tool for identifying witnesses, as I said a moment ago, and again, identifying any potential exhibits that would be used. And again, with identifying the exhibits, just to my point that I referenced before, reading the prior deposition transcripts is very important as well. You also want to find exhibits that are going to help you to visually establish your liability. You want to identify exhibits that are going to help you visually establish your damages. Oftentimes when the deposition is done, or mediation or trial, but more so at the deposition, because that's the first introduction where all of the parties have a chance to see one another in person and question one another. Sometimes when you see the images of the liability from a horrific car accident or a botched medical malpractice matter, it really hits home. So you want to be very specific as to what exhibits you're going to pull and use for those type of things. Also, identifying the exhibits, you have to know your file. You have to definitely know your files, because again, it will help you to identify what would be important. Identifying the exhibits as you go along will also help you to remain organized, so you're not trying to find things the morning of or the day before the deposition. When you know the deposition or mediation, arbitration, or trial is coming, you can just begin to organize your exhibits in a separate folder if necessary, so that you have them and ready to go. And of course, knowing the case and keeping a summary as you go along can help the attorney to present his best self for the client and get the case moving to a positive resolution.
To add to what Nikisi is saying about identifying exhibits, I do believe reading prior deposition transcripts of your attorney is extremely important. You need to learn his style, his way of doing things, his way of identifying the exhibits that he uses as he goes along. You know, exhibits can be split into two categories, usually either liability or damages. And you need to know what liability exhibits help your case, what liability exhibits may hurt your case. You also need to know those damages. You need to know about wage loss. You need to know about medical treatment, prior medical treatment. You need to make sure that you have all those exhibits identified and organized. You also, keeping a case summary. As I go along in my files, I start a case summary when the file first comes in, and that summary covers the file from the minute it walks through the door to the minute it leaves. So what happens is we're able to add to those case summaries as we go through. So once discovery is received, I can make a notation in the case summary that says, discovery has been received from this party or that party. It has been summarized, saved as discovery summary in this location. That way the attorney has a very, very quick reference when he's going ahead and reviewing the file. Do we have any questions?
We do have a question. I was wanting to give credit where credit's due. Liz, let me see what Liz's full name. Well, Liz has written in and says she always likes to meet with the client about 3 months after the client has retained her law firm, so she can get to know the client personally. What do y'all think about that?
That's very important. Getting to know the client personally helps you to walk in their shoes. It helps you to feel what they feel. And then it drives you to want to do your absolute best for that client. It helps to make that connection, that necessary connection, so that the firm and yourself can represent that client to the best of your ability. If you can feel what they're feeling, then it adds value to the case, because you will definitely fight to get the most that you can for that client. So I agree.
What do you think?
I try to meet with the clients from intake. I try to make that connection from the day that I meet them during the intake. And then I stay in constant contact with the clients from the day they walk in the door until their case is resolved.
What do you think, Betsy?
I also try to meet with the clients initially, so either at the intake or very quickly after. I found in the world that we're all now working in this post-COVID world, where, you know, hopefully someday it'll go away. I find that, you know, my personal cell phone is not really my personal cell phone anymore. I find that a lot of my younger clients, instead of emailing or calling, they prefer to text me. Text messages can be easily saved. They can be screenshotted, emailed to yourself, and saved to the file. I find that that kind of contact, the ability for the client to reach you at any given time and, you know, take those moments to build trust with each other, and as well as tell you those things that may pop into their head. You know, I also make it clear that if they text me at 11 o'clock at night, it's not likely that I'll answer, but I do get back to them the next day. I find that a lot of my older clients prefer phone calls, and I try to call them once a month just to see how they're doing, just to see what's new in their life, what's new in their treatment. I try to take a personal interest. I try to remember something about each client. That way, when something does happen, they're more likely to reach out, they're more likely to talk. So I believe probably the relationship you have with your client is the most important part of your job as a paralegal.
I agree.
Do both of you find that you need to set boundaries sometimes? I know some paralegals, we have Georgia Kent, who's on today from our law firm, and it's done these webinars with Connectionology. And she just told me the other day, she loved her client, but the client blew up her phone the other night at about 10 p.m. while she was enjoying watching a movie, eating a little popcorn with her husband. Do y'all set boundaries with clients? What do you think about paralegals you giving out their cell phone numbers, male or female? Do you think the law firm should have some kind of protocol in place to protect the privacy interest of the paralegals?
Well,
I'm sorry.
Go ahead, Nikizia.
I do believe that boundaries are necessary. Unlike Betsy, I do not give out my cell phone number, but I do constantly communicate with my clients via email and telephone call on a regular basis.
Okay.
I try to set expectations with my clients. You know, they know I'm in the office usually 7:30 to 5, so they know between those hours that they can get me at any time. I do have the occasional client who will text me after 5 o'clock, but they're usually those emergency situations where something comes up and they're not quite sure what to do. In those situations, if I'm able, I do answer right away. If I'm unable to answer, I'll occasionally just send them a text message back that I'll get back to them shortly, or I'll get back to them the next morning. I do believe boundaries are important. You need a work-life balance. However, monitoring that kind of stuff and making sure that the occasional emergency doesn't pop up, or taking care of the occasional emergency is just all part of the job.
Sharon Dowdy says we use Google Voice to establish a cell number for the clients to use. And Liz says we have an office text number. It works so much better, still hard to set boundaries. I agree. And Jenna Gorwitsky says texting software within the firm is awesome. Boundaries are necessary. And Matt McMullen says, but you have to be too careful. You have to be careful if you get too passionate and try to push past the point. You sometimes a case can become no longer profitable or realistic to pursue. Do you think you have to be afraid of transference? Like you feel so passionate and feel so bad for the client, what she or he's going through, that you have to be careful about getting too close to it. What do you think?
I agree, and I disagree. I think that connection is very important. I think connection is a very important part of our job as a paralegal. I think it's important to connect to the client. I do understand Matt's view in that becoming too connected can obscure one's ability to properly represent the client. But as the paralegals, we generally are the first point of contact for the client. We would be the individual that the client will call when they are experiencing something, or they are experiencing some uncertainty and need some direction. The attorney would be the one to go to court and represent them there, and may not necessarily have the same connection that we have as a paralegal to the client. So again, connection between the paralegal and the client, in my opinion, is very important.
Betsy?
I also agree and disagree. I do set immediate boundaries. If you are a client of mine, if I am the paralegal on your case, we are not friends on social media.
Right.
I don't join them on Facebook, Twitter, anything that I may have. I don't take those steps just because that is the way that I set boundaries. You know, I'm more than happy to share a story. I'm more than happy to listen to what they have to say, but I keep it very professional.
Right.
I'm always there for them to talk. I'm always there to listen, and I'm always there to help. However, you know, you need to set that professionalism right off the bat. You know, we're not going out to the bar together. We're not, you know, even on the occasional time that I find somebody else who's an avid walker or somebody like that, you know, we're not going to do those things together as long as your case is active in the firm. Just because we always have to stay professional. We always have to, you know, not only think about the firm, but think about the client and keep things in a professional manner.
Correct.
So, you know, as long as you continue to move forward, you can really have that connection with the client. It's just, you want to keep it professional.
So
I
Betsy, no gin blossoms for you, client. If they want to go hear the gin blossoms, that's on their own time, correct?
That is absolutely on their own time. I have actually seen a client or two at a concert, but I have been there, have not known they were a fan, and they came up and said, "Hi, Betsy," and you know, you talk pleasantly, but you know, while they're a client, it's not going to say, I'm not going to say, "Hey, I have an extra ticket in the backstage pass. Do you want to come with me?" That's just not going to happen.
Okay. Well, quickly on this topic, and we'll move on. Karen Bressman says she has a work, end quote, cell phone that is available to clients only. Is turned on from 7 a.m. to 6 p.m. This way they can have contact with me during work hours when they're unable to call the office, but can also send texts with information at a convenient time for the client. Jacqueline Kazoon says, I've used Google Voice for clients to maintain boundaries and will use an away message after hours, though she does monitor the messages in case of emergency. And Liz says she has 138 files that she handles. Phone rings at least 25 times a day, sometimes more. Any suggestions on how to make the client understand I can't work on their file if I'm on the phone with them every day? That never happens to any paralegals other than Liz, does it?
I wish that were the case. You know, there are those clients that need a lot of hand-holding and will call you multiple times a day and call you every single day. I've learned that I'll take the initial call and speak with them, and then I'll just have my receptionist take a message and call them back when I have time to speak with them so that I can focus on my other cases that I am working on.
I have one lawyer friend of mine. She goes in and lets her client talk, and after a while, when she's heard enough, she'll say, well, you know what Dr. Sigmund Freud used to say, and the client will be very impressed and go, no, what did he say? And she goes, your 50 minutes is up, and she walks out. but that's probably not the best technique. So,
No.
okay, so also, this is interesting. Jenna Goretsky says, our firm has set, quote, quiet times, end quote, for paralegals, 2 hours a day. No one bothers us, no phone calls, not even the attorneys. Awesome boundaries set by our group. What do y'all think of that? That sounds fantastic, doesn't it?
It sounds like lunch break to me.
Okay, ladies, we probably have talked about that. And by the way, everyone who's listening, oh Lord, now Georgia Kent, who works with us, says, I want that. Thank you very much. Thank you very much, Jenna. Now we're going to have to implement that at our office. So, and all of you are attending today. This is great stuff. Keep in mind, we already knew how these ladies were going to rock it today. We're going to do a part two. I'm already telling you, we're going to do a part two if they'll agree to attend again, because they have so much material. So anyway, so what's next? So who's doing what? Where we're going to pick up?
Yeah, Doug, before we move on, I want to go ahead and introduce our two incredible partners. We're bringing in, so Betsy, if it's okay, we're going to close out of this just for a minute, and we're going to bring in Diane, who's here with us right now. I'm so excited with On Point Litigation. What did I say? On Point Litigation, On Point Legal Nurse Consulting, and she's going to be speaking with us today. And then also I've got Kyle Kinberger, who's coming in from HMR. So I wanted you guys to meet him for a minute, and he's going to tell you guys a little bit about what they do as well. So I'll let him join in for just a second. And for those who don't know Kyle, he is wonderful. He actually lives in New Orleans, but they work with clients all over the country. Later on in this webinar, Ted Mullis is going to jump in and do the coffee giveaway for us. So I can't wait to see who wins. But Kyle, thank you so much for joining us today, and tell us a little bit about what you guys do.
Yeah, you got it. Thanks for having us. Hey, Doug, how you doing, bud?
Good to see you, Kyle. I just saw Kyle at National Trial Lawyers and Mark Lanier's Trial Academy.
Yep.
And it was great to see you, Kyle. And I appreciate the receptions you did for everybody was invited. Thank you. And I really appreciate you staying up on the cutting edge technology and techniques. So it's great seeing you, Kyle. Thanks for
you too, Doug.
Yeah.
So for everybody who's attending, if you haven't had any experience with HMR, at our core, our company is a medical funding company. And so a lot of times attorneys and law firms will come to us when they have clients who have been injured, but they don't have health insurance to get the medical treatment they need when they need it. Or in some instances, they're underinsured, so they might have Medicare or Medicaid. And it really becomes a way for people to get that treatment while their case is ongoing. All of the funding that we do is non-recourse. So typically what we would do was vet some of the cases just like a law firm would to make sure that there's enough insurance coverage, that causation is there, liability looks okay, because all of the funding we do is non-recourse. And we do this across the country. Typically we get involved on cases where people need a spine surgery, or they've got a brain injury and they need a facility or a neuropsychologist or a neurologist, or they've got an amputation and they need a prosthetic company to do a fitting, all the way down to imaging and PT and pain management. So we kind of do that across the board. I think one of the things that I really don't talk about enough is the fact that our back office really acts as a huge support system to a law firm. They are getting estimates for procedures, they're scheduling appointments, they're corresponding with you all to make sure that you know that your client's been scheduled, that they've been communicated to by the provider. We're gathering bills and records that are all certified so you can put a demand package together, whether it's for mediation or trial. So it really becomes not just the money, but a time-saving tool to be able to run things a little bit more efficiently. So I've probably talked longer than I should. So I appreciate the time. And as always, Ginger and Doug, thanks so much for having us.
Hey, Kyle, before you do it, we have a big crowd today. That beautiful painting behind you, can you tell me what that is?
Yeah, sure. No problem. Like Ginger said, I'm right around New Orleans over here. And so behind me, this is it's Oak Alley. So it's about 20 minutes outside of New Orleans. And there's this big, beautiful historic plantation that's actually set at the end of all these oak trees. But those oaks probably span about a mile long that you drive through to get there. So
Thanks, Kyle. Yeah.
Absolutely beautiful. Thank you so much, Kyle. And don't forget, put your information in the chat box. That way everybody can reach out to you, okay?
Absolutely.
Thank you so much for being with us today.
Thanks.
And now it is my absolute pleasure to introduce Diane with On Point Legal Nurse Consulting, who's going to be sharing a little bit more about what they do today. But I wanted to ask you, Diane, for those who haven't had the opportunity to work with you or the legal nurse consultants, can you tell us a little bit about how you can assist them in the support of the case? Oh, you're on mute. There we go.
There you go. Sorry about that. Yeah, it was really interesting listening to Betsy and Nikisha talk about how, I don't want to say stressful, but how overwhelmed they can get with all this information and taking care of clients and everything like that. And it just was a perfect opportunity for us to talk a little bit about how we can help simplify the medicine in the review of medical records. You talked about these copious, medical records. They're voluminous. I mean, some of these complex cases can take so much of your time. So we like to say that we simplify the medicine for the law firm, for the paralegals, for anybody who needs our help, whether you're juggling complex cases or you just have a lot of cases. Coming out of COVID, we're hearing from attorneys that they are just overwhelmed with the amount of requests that are coming in. So we like to say that we bring really valuable nursing insights into the review of the medical records. I think, Nikisha, you said something about how it's so important to uncover those hidden gems in the medical record because you don't want to be blindsided. You don't want to miss something that the defense found. So detailed timelines and chronologies are also helpful. We can do them for you. And Ginger, I was going to share my screen real quick. I was just going to put up this, I don't know if it's gonna, let me just share. Okay, so I just wanted to talk a little bit about the timelines and chronologies that we can do. We can also do case analysis. Some of the things listed here, I think both you guys, Betsy and Nikisha, both mentioned how important it is to really go through the medical records, do that chronology, outline strengths, weaknesses, missing records, potential defendants. And we can certainly do that. We know you guys do a great job, but if you get a case that's a little bit more complex or you're juggling more than one case, we'd be happy to serve as a backup.
Great. And then now, does it have to be a particular type of case?
No, we can do all kinds of cases. We've been supporting attorneys nationwide for about 25 years. And medical malpractice, PI, nursing home, slip and fall, anything that has a medical component, we can assist your teams with.
Right. And then I also heard that you guys do something with nursing medical division. Is that right?
Yeah, we have a nursing home division, and it's unfortunate, but with the heightened awareness of elder abuse and nursing home injuries, we decided that this type of litigation needed a specific program. It's run by Ingrid Sidoroff, who has about almost 40 years of gerontology experience. So if you have any type of nursing home litigation that you need a review on, a simple merit screen, a thumbs up or a thumbs down, a chronology, or if you need an expert specific in that long-term care arena experience, give Ingrid a call. She'd be happy to help. You guys know, any of you are using legal nurse consultants in your practice now, that streamlining the trial prep and case support can be a lifesaver when things get backed up. locating and vetting experts can really suck up valuable staff time. So we'd be happy to take that off your plate whenever you need it. And if you're heading to mediation or trial and you need a damages package prepared, we'd be happy to do that as well. Life care plans and pain and suffering reports can really be helpful at that settlement table, just helping explain your client's story. So if you guys need any help or you need any questions answered, give me a shout. I'll put my information in the chat box for you. And, or you can go right onto our website and click contact us and put your case information in there. And we'd be happy to call you back for a free consultation.
Great. Thank you so much, Diane.
Diane,
And you guys have an amazing team.
I have a question for Diane. Diane,
Yes.
still
Hi,
there?
Doug.
First of all, did we not meet for the first time at a Connectionology seminar? Where?
Harrisburg.
And we have 2 Keystone State paralegals right here. And
Yeah.
are you coming in from Pennsylvania today?
I
No.
am. I'm in Bucks County.
Okay, so we have a heavy emphasis on Pennsylvania today, which is a good thing.
Yeah,
But
that's great.
Diane,
Betsy-
also, like Kyle, if people call you, is there a cost to consult with you just to ask your questions and maybe say, I need some help finding experts? Do you have any general ideas? How do y'all do that?
Yeah, you can just call us. You can call the office line. You can email me. You can go on. We have a great contact us on our website, and it'll say, give me some information about your case and whether it's an expert, nursing home, or behind the scenes consulting. We'll make sure that the correct program coordinator gets your request and they'll get right back to you.
All right, and I see Kyle's put his contact information with HMR. Liz has asked, be sure to share your contact information. And I think one of our attendees, I don't see his or her name, but says On Point is awesome. Very helpful and dependable. So would you please put your contact information in?
Yes, I will. And thank you so much, girls. All your slides are spot on. It's just great to see how someone told me once that paralegals are the glue that holds the law firm together. And listening to you two guys, I'm thinking they are right on. So good job. Thanks so much.
Thank you.
Thank you.
Alrighty.
Amen.
Thank you so much, Diane. And
Hey,
now
Ginger, I'm fired up by what I'm hearing so far, and we're going to get right back to it. But for the first 25 people who contact Doug Beam at dougbeam.com, you get a complimentary jury doodle, not jury doodle, a discovery notepad. It's environmentally friendly. We have them custom made here in Melbourne, Florida, United States of America. You'll get a 2-pack for free. That's 2-pack. Betsy, that's not the wrapper. These are 2-packs, not 2-pack. Okay, I don't want to lose my street cred. You'll also get a Seeking Justice little cards we use. Just, it's easy to use in the office. First 25 paralegals who write Doug Beam at dougbeam.com will see that you get those. So back to it, ladies.
All right, so now that we're going to get back to it. Now that we have our files organized, now that we've identified our exhibits, now comes the time for actually preparing binders. The first set of binders I'm going to cover are deposition binders. And deposition binders, how I do it is I make a client binder as well as an attorney binder. I know a lot of people are going to say, but my client will never look at the binder. I do find that preparing your client that a binder is coming, making sure they understand what's in it, and also doing a prep for your client as a paralegal. So yes, I do a pre-prep to the attorney's deposition prep. So I'll make sure the client has the binder, usually 2 weeks in advance of the deposition. And then a week before, I'll give them a call and I'll say, hey, are you looking at your binder? Do you have it out? Can we go ahead and go through some stuff in there? And I'll take them through different aspects of the binder so they really, really see the different things that are in that binder and how it's going to help them in deposition. I'll also explain to them, how the defense attorney is going to question them on some of these items and I'll point out the differences of opinion that may be there in the deposition binder. You know, if there's some pre-existing treatment in there that the client has had, I'll ask them about that. And I'll say, hey, at the time of your collision or at the time of your fall, was this even bothering you? Were you treating with anybody? And it refreshes their recollection, just so when the attorney comes in to prep them for their deposition, they're starting to review their binder. They're starting to see that the binder is going to help them, is going to make them a better witness. Because we all know, the one thing I can tell you from working defense for 14 years, that defense attorney, his sole goal was just to make the client look bad, to make them look like they don't understand what they're doing, that they're not treating correctly, that everything is pre-existing. And if you go ahead and do this binder for a client, that client is going to be very well prepared, and some of those easy trip ups that happen aren't going to happen because the client knows about it. My attorney binder, what goes in the binders? I usually split them into two separate categories of liability and damages. This is where reading your attorney's deposition transcript comes invaluable. That way you learn his style, his way of presenting things, the chronology that he does, and the order that the deposition usually goes in. So he's able to review those items, and he's able to prepare the client on, you know, how the deposition is going to flow. Now, this is a sample of one of my deposition binders. As you can see, you know, I usually start out, if there's a police report and a notice of accident, a notice of claim, any of those items would be the first thing in the binder, because that's the first thing that your client is going to talk about. How this happened, how they were injured. So I make sure that type of thing are in there. If it's a car accident, I make sure there's the vehicle estimate. I make sure there's great photographs. I find that, you know, calling my client and saying, hey, do you have any photographs on your cell phone? Can you text those to me? Is invaluable, because I end up with so many different versions of the vehicle damage. You know, I have our professional photos that maybe were taken by an investigator or somebody here in the office, but I also get those scene photos, those ones that you don't really have all the time, but are so incredibly powerful because it's that minute saved in time. You know, I go through their medical records. You can see in this on Exhibit H, I actually provide my medical summary to the client. You know, to think that a client is going to sit there and read hundreds of pages of medical records isn't feasible. There, you know, very few clients are going to go and sit and read all of their medical records. So what I do is I give them a copy of my medical summary, because it's more likely they're going to read 10 pages than reading 500. You know, I make sure all the records are in chronological order. So as the attorney goes through his binder, he is able to, you know, follow their treatment from the very first day it starts, whether it's an ER visit or a visit to their primary care physician, all the way through to their most current treatment. And I make sure that each and every exhibit is in chronological order. I don't know about everybody on the thing, but we have a Geisinger Health System here in Pennsylvania, and they give us flow sheets. These flow sheets are never ending. There's usually 5 pages of actual records and 500 pages of flow sheets. So although I review the flow sheets to make sure there's nothing in there, they never make it into my binder. There's no sense in it. There's no reason to put that in the binder, because the attorney is not going to get any information from them. You also see that I always give the client and the attorney a copy of the complaint in the binder. You wouldn't believe how many defense counsels ask the client about the complaint. Yes, that is legal in nature, but the client did verify it. So I always make sure the client has a copy of the complaint and that they review it, and that the attorney always needs a copy of the complaint to go ahead and review with the client. You know, I'll put in any lien information I have. I'll put any settlement information I have in. I'll put in the answers to discovery as well as my discovery summary. I'll also make sure the client has a copy of their discovery answers, because that is where most of their deposition questions are going to come from. So my differences between the attorney binder and the client binder. The client binder is just straight. It is, as you can see, it's lettered. I usually use exhibit tabs, and I go ahead and letter the binder so it's easy for them to read through. However, I do not take the extra step of highlighting anything, tabbing anything, or putting any additional notes. That I save for the attorney binder. So what I'll do is I'll go ahead and highlight important points in the medical records or in the police report. If somebody was charged with something, I'll make sure that information is highlighted so it jumps out at the attorney. I'll also tab the medical records for easy reference. My medical summaries will now have notes or my impressions, or if the client has something that is not usual, I'll make sure that medical term is defined for the attorney so he's very well aware of what this unusual condition is and what the symptoms and the signs. I will also, do the same thing with the discovery summary. I'll highlight different things. I'll make sure it's tabbed in the discovery. That way he can quickly and easily reference those materials. I do make a deposition binder for the defendant. That deposition binder will usually have the defendant's social media. If I happen to have defendant's discovery answers, I'll make sure, the defendant's vehicle estimates, pictures. I'll make sure scene pictures, even if it's a slip and fall at somebody's house, I'll make sure those scene pictures are there so the defendant can't try to say, oh, well, it didn't happen here or it didn't happen this way. I will make sure all those type of items in there. And even if I have statements of witnesses, I'll make sure they're included in the client binder, the attorney binder, as well as the defendant's deposition binder. Okay, virtual. Now, I keep saying the word binder, 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 and most people are hearing are paper, paper, paper. The thing about that is I actually do virtual deposition binders. I usually contact my client and I ask, do you want paper? Do you have the ability to review this stuff if I send it to you in a virtual format? I do have an attorney here at the office who actually likes the virtual format. So I will put, I will make a folder and I will put the items in there that he can just review on the computer. So he doesn't actually have a physical binder. Different formats for the client. You can use Dropbox, you can use OneDrive, you can just use a flash drive, USB drive, or you can use some type of file share. Each exhibit has its own folder for easy reference. And I use programs for the attorney, such as Adobe Acrobat, to highlight and tab different items inside the binder. And I still have a way to mark the important points without having to actually print out paper and highlight or mark that up. Do we have any questions on depositions? All right. I'm going to go ahead and move on.
Betsy, we do have one that sort of relates to that. What type of information from earlier is contained in the client summary, and how often do you create a new summary? Is there perpetual updating? Can you just talk a little bit about that early in the case? And obviously you're careful what you give your client because you don't know what they're going to show to people, right?
Correct. If we're talking the medical summary, I do a chronology. So I go through the medical records and I use what Nikisha talked about before, which is the subjective objective assessment and plan. And I stick to the medical records. The only person who gets my thoughts or my impressions are the attorney. And his medical summary will have those type of things in them. The client does not get that. They get the records and the records only in their summary. But as for my case status memo, that is for in-house only. I do not give that out to the client. That is for the attorney reference. The different things contained in that, I start off with the client's name and address. I put their phone number. I put their email address in there. I make sure I note the insurance company, any insurance adjuster, their phone number, their email address, possibly their fax number. I do the facts of the case. I do the current physicians that they're treating with, including addresses. I do the status of discovery. I do the status of the medical records coming in. I also do, the status of a deposition. Has a deposition been taken? Has a deposition summary been completed? I update those periodically throughout the case. However, when I get close to trial, when I know something is going to trial or arbitration, I will go in and update those completely. So we have a reference to what's going on, and we do have an opportunity to obtain anything that we may have missed, or we may not have seen, or that we didn't necessarily know about. So that's how I work on my case summaries, but they are completely an internal document. All right, so we're going to go ahead and move on to preparing mediation binders. Difference between who gets a mediation binder? The attorney, opposing counsel, and the mediator. We're moving into the age of virtual. We are moving into the age of paperless, and I note that defense counsel or the mediator may actually prefer a virtual binder over a paper binder. I usually reach out to both. I'll reach out to opposing counsel as well as the mediator, and I'll ask them what they prefer. Would they prefer a paper binder, or would they prefer something virtual? Our office mainly uses Dropbox for those type of things. However, if opposing counsel or the mediator would like me to do it in a different format, or use OneDrive or a file share or anything like that, what I do is I make the binder virtual on our system. So I create a folder, I call it arbitration or mediation binder, and I'll put the exhibits in there. I'll go ahead and number them, or put them in letters that, and I will bait stamp them occasionally, depending how voluminous they are. And I leave it up to their discretion. That way, what I can do is I can take that folder and I can drag it into any virtual medium that opposing counsel or the mediator would prefer. I still do a lot of paper binders here for the office. So I do a binder for the attorney. I do not give one to the client because they're in a mediation, there is no client testimony. So I just don't feel that giving them a binder at a mediation is worthwhile. They're there to observe. However, I will share, we use PowerPoint service to build our PowerPoints for mediations. And I will make sure that they have a copy of the virtual binder so they have everything available to them for any PowerPoint that they may be doing. I don't go to the extreme of highlighting or marking a mediation binder because I'm mostly working with the PowerPoint person to make sure the appropriate information gets into the PowerPoint for a mediation or arbitration. Although you still have to be very prepared for your mediation, it's not the same thing as an arbitration or a deposition. What do I put in my mediation binder? Again, here's a sample. It looks very much like a deposition binder, with the exception of it goes through the entire case. Usually you're towards the end of your case when you're in a mediation. So these are going to have deposition transcripts in them. We're going to have various photos of the client, doing things that they maybe love to do at some point in time that they can no longer do. Sometimes I'll have a client send me a video of their home exercise program or pictures of a home exercise program. And I will include those in a mediation binder because they become incredibly important for the mediator to understand just how different your client's life may be from an injury. Do we have any questions on mediation?
I have questions for you and Takesia too. Do you keep a list of preferred mediators how do you play that game? Because oftentimes a plaintiff's lawyer will recommend 4 mediators, and the defense immediately rejects them, and then the defense offers 4 mediators, and the plaintiff decides to respond in kind. Do you list them in order, knowing they'll be rejected? You know some are accepted. How do you, both of you, work on mediators, and do you work with your attorneys in the selection of a mediator? How important is the selection of the mediator? What's your experience with that?
We live in an area where there isn't a massive amount of mediators. You know, I work with Attorney O'Donnell, and he usually chooses the mediators that he wants to suggest. We kind of know right off the bat what defense counsel will accept and what they won't. So usually, if we're naming 3 mediators, we have one on that list that we would accept, as well as we know that defense counsel would accept, because we work well together and we are, you know, we're aware that the mediator works well with everybody.
And to Betsy's point, I function the same way with the attorneys in my office as well. I rely on them to name potential mediators and or arbitrators, knowing that the defense counsel will be amenable to choosing one of the individuals that have been proposed.
Do you ever try to match up your client to a mediator personality-wise?
I actually have not. I find that, you know, prepping a client as a paralegal, so talking to the client as a paralegal, I find that, you know, I know these mediators, I know these arbitrators, and, you know, I'm able to prep the client and help them tell their story in the most appropriate way. So I do not, however, I can't speak for the attorney. I don't know if he, you know, has that in the back of his head when he's suggesting a mediator or arbitrator.
And we, again, to Betsy's point, we operate in a similar manner as well. In mediation, the client isn't questioned as they would if it were an arbitration. So of course, picking an arbitrator versus a mediator, the thought process would be slightly different. But to Betsy's point, our firms tend to operate the same way in that regard.
Our paralegals, we do 1 or more meetings, pre-mediation meetings with our clients to prepare them for what a mediation is,
Mhm.
to reassure them. We go over everything from how they dress. Now we still have primarily Zoom or similar platform mediations. How do y'all handle that?
That is actually my most asked question for mediation or arbitration is, what do I wear? Yeah, that, you know, it's one of the first questions that come out of the client's mouth. And I tell them, you know, if we're doing it via Zoom and they're sitting at a table where, like we are right now, where you can only see the upper half, I say, please wear a very, very nice shirt. As long as you're not getting up from the table and walking around, wear pants, but I don't necessarily care what those pants are. However, if, you know, if they're in person, I tell them to dress business casual. So men, a nice button-down shirt, women, a nice blouse, and whether, you know, it's a really nice pair of jeans that don't have any stains or anything on them, or just a pair of khakis if they have them. You know, so that is actually one thing that I do cover as a paralegal. I have a big affinity for shoes, and my clients, that's one of the first things they seem to notice about me. So I guess they maybe feel comfortable talking to me about their attire and what they should wear to different things. You know, but it's kind of a fun little conversation that I get to have that I actually enjoy.
Yes, and when I'm preparing the clients for mediation or arbitration or even deposition, and I'm asked, you know, what should I wear? I tell them to come comfortably, no jeans and sneakers, a nice shirt. A tie is not required. I also schedule time for the client to meet with the attorney a few days before, block out about 2 hours time so that the client can review the mediation and or arbitration brief with the attorney, ask any questions that they may have, address any concerns, let the attorney explain to the client the importance of getting across how their life was before the accident versus what their limitations are now, and just prepare them for the type of questions that could be asked and the best way to answer them.
I happen to be a certified mediator, and I will tell when I'm actually the mediator, I will tell the participants, this is mediation, it's not meditation. You know, we're probably not going to burn incense and pass granola around and then sing Kumbaya. However, if they want to do that, that's as far as I'm going to go. But, you know, well, I'll do that if it'll help them get to yes. I think it's really important that the client know the difference between mediation and arbitration, for instance.
Absolutely.
You know, arbitration can be binding or non-binding, and that's a huge difference. And have you, both of you, seen a tendency now, particularly in your larger cases, for mediation to not the big cases not getting done in the first mediation? Betsy, you worked on the insurance side. There can be a utility in discouraging the claimant or plaintiff, can't there, by having multiple mediations and draining them emotionally or wearing them down. Have y'all seen that tendency? We see it here in Florida and other parts of the country.
I would have to say probably 85% of our mediations resolve at the first mediation. But yes, when we get into a bigger case, especially when we get into those cases where there's been no initial offer, we're going into mediation with the defense not giving an initial offer. I find that those are the ones that are really, really hard to resolve at mediation. From my time working for defense counsel, from my time working for claims adjusters, I find, and this is an entirely different topic, and I'll just stop short. I find that if the attorney, if the defense counsel and the claims adjuster don't have an appropriately set reserve number on the case, you're not resolving at mediation. You know, if the claims adjuster said at the beginning of the case, oh, this case is worth nuisance value, until you get to somewhere, or, you know, you get to something that's binding like an arbitration, or, you know, even to the doors of the courthouse, that case isn't going to resolve easily. I used to laugh and say that it would take an act of God or an act of Congress to move a reserve when it was set that low. So it really does depend on the case. You know, when there's no realistic offer before a mediation even commences, or there's no offer at all, you're less likely to go ahead and resolve that case.
And I have most of our cases, when they go to mediation or arbitration, they are resolved. However, there have been occasion where 2 mediations were necessary, or a mediation and then a binding arbitration was necessary in order to resolve the case. And that has happened because an offer wasn't made, or a realistic offer wasn't extended to the client. Once it gets to the second arbitration, or it goes from mediation to arbitration, the clients are pretty worn out at that point and ready to get this over with. And in situations when that has happened, the case was resolved the second go round. But it's not something that happens very often within our firm.
And by being so prepared, don't you think you drive the value of the case? They know the law firms on the insurance defense side. The lawyers know the paralegals who are prepared, make their lawyers look good, have the clients looking sharp. That drives the value of the case, doesn't it?
Absolutely.
The better witness the client is, that the higher the numbers are going to be, the more likable. The more likable you can make your client, the more real they seem to a claims adjuster. Like if the claims adjuster is attending the mediation and your client comes in and the entire room lights up just because they're there, because they're so likable and they're so real and they're, you know, somebody that you just want to hang out with, I find that that is a way to make them resolve more quickly, because the claims adjuster is going to know that you get that person in front of a jury and they're going to win the room.
And I think seeing the client in that particular situation is just putting the icing on the cake, because up to that point, the claim adjuster has spoken with the paralegal, has spoken with the attorney, has received the documents that we have provided to them. We've pretty much worked up the case very well up to that point. And so when the client walks in and lights up the room, that's just putting the icing on the cake and helping to drive it to its conclusion.
Talking about driving, in some of our cases, we will pick up the client, drive the client to the mediation. We do not leave a client alone during mediation. We even have if we have a female client, we have paralegals there. We have a female paralegal walk down the hallway with the female client when she goes to the restroom, because things can happen. People hear things while they're in a stall being discussed at the sink. Same thing in the men's restroom. We do not leave our clients alone. We don't leave them alone with the mediator. And frequently we will take them to the mediation or have the paralegal out front, tell them we don't want them riding in, you know, looking like a bat out of, you know, where. We're very careful with that. Also, I think you have clients, it's like putting lipstick on a pig. You know, pig doesn't look much better and it annoys the pig. We always have to dig deep to find something good about our clients. There's one client, the best we can say about him, God bless him, is when he goes home at night, he doesn't kick his dog. Okay, that's about it. So we have to really spend extra time with that guy to get him presentable for mediation. But you know, he's hurt and he deserves to be compensated. Even if he's a multiple convicted felon or has all kinds of other issues in his life, he deserves to be compensated. So that's my speech for today. Back to you two.
Yeah, I'm excited. I wanted to introduce you guys real quickly to our last two amazing partners. Looks like Connor McDuffie is coming in from Strategic Relationships, and they do an incredible job over there. There's nobody else in the country that I know of doing the work that they are. They're finding these incredible like ex-employees that you would never believe you could find, that literally come in and they basically help turn the jurors against the defendant, right? Is that right,
That's
Connor?
correct. Yeah, that's exactly it. That's exactly it. Thank you, Ginger.
Look, I'm working with you now.
Yeah, right.
But anyway, we love what you guys do, and I'd like for you to share a little bit more about it because it's very interesting.
Absolutely. It's great to see everybody. Ginger, thank you for that introduction. So yeah, that's pretty much what we do. We specialize in identifying ex-employees of your corporate defendant and then flipping them into insider witnesses or whistleblowers. And the way we do that is we produce what we call an EAL, or an ex-employee list. And this is a list that contains the name, the job title, the tenure, and then most importantly, confirmed contact information of those ex-employees. From there, once we have your list, we can come in with our interviewing team. We've got 7 people on staff that will call and vet everybody that's on that list. Right now, we're averaging 33 names per list. So it's a good amount of people to call. So we'll do that for you. And then really just find out what these ex-employees know. It's amazing what we're able to find out, whether these individuals are disgruntled or not. They still know the ins and the outs of your defendant. They know and have seen that negligence firsthand, and they're willing to talk about it. So I have redacted copies of this EAL. This one specifically is from a nursing home case. but we handle all types of cases with attorneys all across the country. So if you'd like a redacted copy or just learn a little bit more about what we do, I'd love to discuss that with you. My information will be in the chat below, and you can call, text, or email me anytime. Thanks, Ginger.
Fantastic. Thank you so much, Connor. And you guys definitely reach out to him if you have any questions. I'm getting asked all the time, what the contact information is for Strategic, and they just do amazing work. It's incredible how you guys can turn a case completely around for the better. So
Absolutely.
Thanks for being with
Ginger.
us.
Yeah.
We'll see you tomorrow for the next webinar, okay?
Good to see everybody.
And now I'm so sad. I know Leon with Fast Funds is not able to join us today, but he has created a special video for all of you to tell you a little bit about what they do. So Doug, if you could give me the thumbs up in a minute, I want to make sure that everybody can hear this. And I'm going to go ahead and share my screen, okay?
Thank you for the introduction, Ginger, and thank you to Connectionology for allowing us to support your great organization and the work that you do for attorneys across the country. My name is Leon Branham, and I'm with Fast Funds. For those who aren't familiar, Fast Funds was one of the first ever litigation funding companies. We were founded about 25 years ago by a trial attorney to serve the needs of plaintiffs and attorneys, and we provide non-recourse attorney and plaintiff funding solutions on an individual case basis. We all know it's an uneven playing field. Plaintiff attorneys must cover their own expenses on every case upfront on a contingent basis. Meanwhile, the defense has their fees and expenses covered by deep-pocketed insurance companies. This creates a culture where the defense delays case resolution and will attempt to outspend you as a tactic for your client to accept less. So what are your options? Well, you can self-fund one case at a time, but what about your other cases? What about your overhead and your marketing budget? You can refer your case, but if you don't cover the expenses, you're going to give up about 40 to 75% of your fee in that case. You can try to stretch your dollar on less expensive experts, but the saying goes, when you pay peanuts, you get monkeys. And we all know that good experts are worth their weight in gold. You can go to a bank, but banks give you an umbrella when it's sunny and ask for it back when it rains. They're regulated, therefore they're unable to value your assets, which are your cases, because they're on a contingent basis. Or you could accept less than your case is worth and live to fight another day. Well, there's a better way. We developed a unique funding product for plaintiff attorneys to help cover expenses on individual cases on a non-recourse basis. That means there's no personal guarantee, there's no lien on your portfolio of cases or your attorney fee. That allows you to move more cases along now by engaging the right experts where they are needed most. You decide what your case needs and which experts are best. You might need an expert to work up damages or one to prove liability. We have funded several different experts, and from life care planners to accident reconstructionists, economists, demonstrative aids, and so forth and so forth. And what the experts do time and time after again is increase the value of your case and decrease the time it takes to resolve. We've got success story after success story of attorneys who have used us to get the right experts. For example, an attorney in Pennsylvania that focuses on nursing home, by using us to get the top experts, his case values have increased on average from 175 to 380. We work with OnPoint that has a $2,500 medical cost projection report, which the attorneys say have increased the value on average 75,000. So imagine you had 14 cases a year and you invested in that medical cost projection report and increased the value of your cases on average 75,000. Well, that's an additional $1 million in recoveries that you can have. TBI cases, we all know those are difficult to prove. Well, attorneys have been engaging us to get the DTI imaging to help prove the TBI and report that once they have that positive imaging, that the case settles shortly thereafter and for large amounts. And especially in this past year, clients may be unwilling or unable to get surgery. So many attorneys have engaged us to get life care plans, which help prove or work up the damages and show what the future medical costs will be and increase the case value significantly. We'd love for your case to be our next success story. So please feel free to contact me directly. There's no cost, no obligation. Even if you want to see if there's a suggestion for an expert that we've used with another attorney that might be of benefit. We look forward to being of service. Again, we're thankful for the opportunity, and I look forward to hearing from you. Thank you so much.
All right. Thank you so much to Leon. I'm going to put his information in the chat box for everybody as well. And then I'm going to go ahead and turn it back over to Betsy and Nikisia.
Okay, is everybody still with us? So the next thing we're going to go over is preparing an arbitration binder. An arbitration is more like a mini trial, usually without expert testimony. Again, who gets binders? The arbitration panel, whether you have an individual arbitrator or you have a panel of 3, depending on what the insurance policy seems to dictate. The attorney, so your attorney, opposing counsel, as well as the client. Why do I give a client a binder this time? First of all, the client's likely going to be testifying, and they need to be prepared. So, there's going to be prep sessions involved, similar to a deposition, but this is going to be direct testimony. So your client needs to be prepared with their medical records, with how the incident happened. And the best way to do that is, again, to make sure that they have all the documentation reviewed, that's needed, especially before you prep them. The preps go so much easier if the client is actually prepared. This is the one time where I make sure my client binder and my attorney binder are identical in structure. That way, if in the current climate, we end up prepping a lot of clients over the phone or via Zoom or some other platform. That way, if the attorney tells the client to go to Exhibit A, page 3, the attorney and the client can both make it to that page. Again, I include any medical and discovery summaries, and those summaries have been updated to the current date. That way, the client is 100% current with their treatment. What goes into my arbitration binder? Again, this is a sample of one I just recently did. You can see, again, it's very, very similar to a deposition or a mediation binder. However, you're going to notice that this one is going to have expert reports in it, narratives. It's also going to have the defense's DME or defense medical examination. There's going to be more information in an arbitration binder. I find that the DME actually seems to make the client upset, because they're usually false. The defense medical examiner takes just the smallest thing out of context and tries to twist it to upset the client or to make the case look better in their favor. I find that this actually helps the client review and know their medical records better. They want to make sure they understand how a defense medical examiner could say that about them. So they want to understand their medical records so they're able to testify correctly. Again, I set it up under the category of liability and damages. I make sure everything flows. So as the attorney's doing his prep, as he's following along for his arbitration, he can take his notes and know that the binder is going to follow along with him. The binder for opposing counsel, the binder for the arbitrator are just plain. There's no highlighting, there's no tabbing. I don't pull anything specific in those binders. I actually do include the cover letter to either opposing counsel or to the arbitrator. And I also make sure a copy of the arbitration memo is inside that binder. Now, again, if I'm doing this virtually, I'm doing the same thing. I'm creating a folder. I'm reaching out to the arbitration panel or the sole arbitrator. I'm reaching out to opposing counsel and I'm asking, how do you want this? Would you rather a paper binder or would you rather something virtual? The binder looks the same either way. It's just in different formats. Now, the next picture is the binder that I give my attorney, the attorney working on the case. As you can see from this binder, it's set up very similar. It's, A through, I think this one was T. However, you can see the little tabs with my markings and my notes on them. The client had a month gap in treatment. There was an aggravation of a pre-existing condition. I note a flare in his condition, and I have those records highlighted to bring the attorney's attention to that flare, to whatever the client said. I was actually able, in this case, I attended the arbitration with the attorney virtually, and defense counsel actually tried to pull out this aggravation note and say, well, see, he had these complaints before this ever happened. Well, guess what? This aggravation note had the same exact complaints. So the argument was invalid. So this is more of what my binder looks like for the attorney compared to what a straight binder looks like for the client or for the arbitrator. I know we're at time. Doug, do we want to continue trying to get through preparing trial binders? This is a bigger section.
Will you two come back on another date and join us and pick up where you left off?
Oh, absolutely.
Yes.
We've just scratched the surface with Nikisia and Betsy, so we're going to have them back. So with that invitation out there, we'll get another date on the book. And Ginger, do you have a coffee giveaway or something for everyone?
Yeah, absolutely. We actually only have one winner today, Doug, but Ted Mullis, who is the director of marketing over at HMR, he is joining us in just a moment, and he's going to announce the winner. So Ted, are you there with us?
I am. Hey, how you doing?
Hey, Ted.
Thanks for joining us. We really appreciate it. We're very excited to see who's going to be the winner. Oh, what was that?
I said I'm green today for some reason. Something didn't work on my video.
Oh, no. Well, hey, we're very excited. Let us know, what is the prize and who's the winner today, Ted?
Yeah, so this is 4 bags of Peruvian coffee, and it is just fantastic coffee. It is sourced out of, obviously, Peru, and some of the proceeds go back to the farming communities that the coffee is sourced from to help with educational initiatives. So there's a feature of giving back to the communities where the coffee comes from. And I know Ginger's had it. I'm sure, Doug, you've had it. It is tasty coffee. So I look forward to giving out 4 bags to, it's Michela Del Cid from Jackson, Mississippi. And if I didn't get your name right, I'm so sorry, but you're going to love the coffee anyway.
Congratulations. And actually, I believe Chuck McRae is the attorney in her firm. They have a great group over there out of Mississippi. Wonderful. So congratulations. And Michaela, both Ted and I will reach out to you in just a few moments and make sure that you get this fresh coffee delivered right to your door. So
Ted, I wanted to share with you, you sent me 4 bags. I didn't win them. You just sent them to me. Thank you. It never made it past our snack room at the office. They loved it. So I wanted to tell you that.
Great.
Really appreciate it.
I did remind everybody that if you didn't win today, that there's still a chance to win tomorrow, because we do have another webinar at 3 o'clock. You can go on to connectionology.com to sign up. And we have so many new presenters and topics that we are releasing. So please stay tuned and sign up. Thank you for watching them. Thank you for sharing them with all of your attorneys and all of your colleagues, because we really appreciate your support. And again, a big thanks to all of our incredible partners, like you said, HMR, On Point, Fast Funds, and Strategic. And last but not least, I do want to go ahead and share my screen just for a moment. I am going to email this to all of you guys in just a few minutes. I definitely want you to stay in touch with all of our speakers today, especially if you didn't get all of your answers for your questions. They are there for you, and they can definitely send you the first part of the slides as well. And we want to continue this relationship with everybody. We have a lot of great things coming up. And then also, please reach out to our incredible partners as well if you need their help now or even later on down the road. Thank you so much, Doug, for being here with us today, for moderating. And I cannot thank Betsy and Nikisia enough for all of their expertise and their help today.
And Ginger, we want to thank both you and Doug for being here, for allowing us to do this, for giving us this wonderful opportunity and giving us the opportunity to talk and share, you know, the knowledge and the different things that we've learned over my 24 years. And I think Nikisia's 25 years of being a paralegal.
Yes, thank you so much. It's been fun.
Absolutely incredible. And I
was
love
going to
all these
say,
comments, Doug.
Ginger, I was going to quickly say, seek justice, and I'm going to go listen to some Gin Blossoms right now.
Chad.
Their big song is Hey Jealousy.
All right, everybody. I will definitely get in touch with Betsy and Nikisia and Doug, and we will get a part 2 date set as soon as possible. I will definitely email everyone as soon as that's ready. Thank you for watching today, and we hope you have a wonderful remainder of your day. Bye, everybody.
Bye.
Seek justice. Bye-bye.